As the President of the International Court of Justice, it's fitting for me to say a few words about the international rule of law. It is sometimes easy to take for granted the existence of the international rule of law or to forget about its significance, not only for peace, but also for the progress and prosperity of all nations. No state, however powerful it may be, can provide security, prosperity, and clean environment to its people without cooperating with other states. Nor can all the problems of a nation be resolved at the national level. International cooperation has to be based on a system of rules. Unless this system of rules is respected by each state, the edifice of multilateral cooperation may collapse. As much as a state may wish to be free of the legal obligations which bind it to other states, it cannot do so unilaterally without losing the benefits it derives from its cooperation with those states and with others. Therefore, states are not only brought closer together by diplomatic relations, trade, and the technological advances in transportation, telecommunications, and cyberspace. They are also bound together by the web of rules that make possible these interactions. A web of rules inspired and based on the fundamental principles of the Charter of the United Nations and of international law. These rules are not imposed on states by an outside legislator. They are designed and assented to by the states themselves. They are often based on mutual interests and shared values. An international rule of law cannot, however, exist without a judicial body to which disputes can be referred and by which they may be resolved. It is for this purpose that the drafters of the Charter of the United Nations established the International Court of Justice. This was in response to the determination proclaimed in the preamble of the Charter to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. It was also in furtherance of the principle in the Charter that all members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. The statute of the court, which is based on that of the Permanent Court of International Justice, adopted almost 100 years ago on 13 December 1920, was annexed to the Charter of the United Nations as an integral part thereof. This is a clear indication of the importance of the court in the rule of law architecture of the United Nations, of which it is the principal judicial organ.